Can you production?
The impugned judgment dated 5/6/2024 and sentence dated 7/6/2024 passed by the learned Special Judge POCSO Kamrup Amengao in Special POCSO case number 25 of 2017 is upheld and confirmed. Resultantly, the appeal is found to be devoid of merits and is dismissed. Both the conviction and the sentence have been upheld, have not touched. File an appeal to the Supreme Court. Yes. Mention anything? Yeah.
To mention item number 9. Earlier, passover for the day is CD is not received.
Item number 9, CD not received.
It is not received also.
Yes.
No issues. The case diary is not received. Issue reminder. You are on interim?
Yes, Your Lordship.
Interim bill stands extended till the next day. List on
After before, my lord, then 22nd, my.
22nd 4. Yes.
Beverly, Your Lordship. Declaration for item number 15, Your Lordship.
1-5.
1-5, Your Lordship. Due to some personal inconvenience of the.
Sir, is it a check bouncing matter?
Yes, yes.
Check bouncing matter, revision.
I've-
You are for the?
I'm for the respondent, Your Lordship.
You're
We've
for
taken
the,
consent
you're for
from
the
other
respondent.
side.
That means respondent complainant.
Your Lordship.
Respondent. His that check amount must have been stuck for he was convicted. I don't know. Anyway, but it's a old matter. Do it on the next day. You try to do it on the next day. It's
After 2 weeks, Your Lordship.
have you informed the other side?
Yes, yes, yes. Taken the consent from the other.
With the consent of the other side, Mr. Learned Counsel.
I'm R4 on behalf of Learned Counsel N. Anand.
No problem. Learned, your name?
R4, Your Lordship.
R. Kumar, Learned Counsel, appearing for the on behalf of the respondent number 2, seeks an adjournment due to some personal difficulty and submits that the other side has been informed, duly informed. Full stop. Prayer is allowed. Both the sides are requested to conduct a hearing on next or subsequent dates expeditiously. Full stop. List the matter after 2 weeks. Should we fix a date or on a date to be fixed by registry? Registry will fix it.
Lordship, I beg to mention item number 10.
Item number 10, my lord. My lord, there are, my lord, 2 numbers of PS cases, my lord. Tezpur PS case number 766/25 and 764/25. We have received 1 CD, my lord, that is for 764/2000.
Cross cases. Are they cross cases?
Cross case.
But we have the AB that was granted was in 766. So that has not been received. Your Lord.
That is not received, my lord. My lord, allow us some time.
You also seeking adjournment?
Yes, sir. Since the CD is not there. Your Lord.
In this case, in this petition, 2 case diaries were called for, and only one of them has been received. Should I give the number?
My lord,
Being-
there is one mistake, my lord, because my lord, in the, my lord, that is the forwarding day stated is as, my lord, 764, my lord. But my lord, in the, my lord, this option over. The FIR, my lord, I have noticed, my lord, this one is 766, my lord. But yet then also, my lord, another CD is not available.
One of the CDs has been received, and the other is awaited. Full stop. Your interim is there?
Yes, sir.
You'll retain this case diary and call for the other one? What do you say?
If it is updated, Your Lordship.
My lord, 766 we have received, my lord. Then, my lord, 764, my lord, we have to take. We can, your interim asana.
The
CD and take the updated CD.
case diary may be sent back for and procured again with the updated investigation, along with the case diary of the other police case.
Yes,
The
sir.
interim bail stands extended till the next date. Next date, suggested date.
Diya, later diya, kitya lagi? After being. Then it is on 22nd, my lord. 22nd of April, my lord.
22/4. 22/4.
I'm deeply obliged.
Your Lordship. Lordship, with regard to the concern of other side, I'd like to mention item number 7, Your Lordship.
7.
7. I'm for the respondent number 2.
2. Okay. It's a quashing matter.
Yes, Your Lordship.
Anyway, so
Can I act me?
enact. Learned counsel, good name, please.
S. Gautam, Your Lordship.
S. Gautam, appearing for respond number 2, submits that with the consent of the other side, he seeks some accommodation today due to personal difficulty and prays for adjourning the matter for 2 weeks.
Next week, Lord.
Huh? By a week. The prayer is allowed. List the matter after a week on a date to be fixed by registry. Any interim order? No. No interim order. Yes.
Thank you, Your Lordship.
Item number 1.
Any interns, you can sit down. If you, any interns, you can sit down. If there are vacant chairs, you can sit down.
And CDCAS lordship.
Pick up this one after some time. Mr. Arcade Surgery in item number 1 will appear. He is coming.
It's a motion matter. Okay.
Motion.
Get the case diary. Anyway.
Item number 2.
Please, Your Lordship. This is a regular petition, my co-accused. Your Lordship has granted bail to that co-accused person, my lord.
Actually,
Okay.
my lord, into divorce.
Go Pange.
13, Your Lordship has granted bail. Actually, my lord, this is a politically motivated case, my lord, that may not be reflected in the case diary. I will explain, my lord. Right.
Mhm.
It will approve by a lot of this.
Will you get the case diary again?
Lordship, kindly see
Hmm.
the FIR, there is a vehicle is released.
Yes, yes, I'm remembering now.
AS25 FC 8391. Actually, this is a e-rickshaw. I have annexed his registration details that it has page, my lord,
The
20.
registration number of the vehicle mentioned in the
FIR,
is that of a e-rickshaw.
e-rickshaw. my lord.
E-rickshaws have registration
E-rickshaw,
number.
can they carry, my lord, 21
no,
cattle, my lord?
No, e-rickshaws, do they have a registration number like this? Like
Yes.
AS,
Yes,
the
ma'am.
normal?
Yes.
E-rickshaws.
Yes, my lord.
They have?
Oh, yes, my lord. Lordship, kindly see.
No number lordship.
No, the
Registration.
green plate is there, my lord, registration. Lordship, kindly see the.
No,
this
as
is
far
a-
as I know, municipality just gives them a number.
Maybe earlier, now my lord, green
Then
number
I-
plate
I
is
don't
there.
know.
Lordship, kindly see page 20, my lord. This is the vehicle number AS25 FC 8391, my lord. This is a 3-wheeler passenger, my lord. Fuel type, electric, my lord. POV, my lord. Can in a e-rickshaw, my lord, they carry 21 cattle. This is a concocted story, my lord.
No, you know what happened is that it may be a auto rickshaw, electric auto rickshaw. It may be.
Maybe
Because
auto rickshaw. Ma,
nowadays
auto rickshaw 21 cattle.
No,
it is
that's not
impossible.
possible, of course. Not.
It is impossible, my
That
lord.
is not possible. But nowadays you've seen white, blue and white color. A lot of electric auto rickshaws are there.
Auto rickshaw. Maybe that, but this is a passenger, my lord, vehicle.
So I don't know whether e-rickshaws need.
Well, already your lordship
that I-
granted bail to the other co-accused, my lord.
Let the city come because.
Already your lordship had perused, and in the order, lordship kindly see, your lordship has mentioned that the statement of all the accused persons, that is, paragraph 6, my lord. Seen the progress of investigation, including the statements of the accused persons, has been recorded. The present petitioner in his statement admitted that he has earlier also involved in interception of cattle carrying the vehicle, but he denied that he took away the money, any money, or assaulted the driver. Considered, my lord. The statement is already, lordship has perused the case there, my lord.
If you can wait 2 days, we can get the case diary day after tomorrow. Day after tomorrow, or even tomorrow if you want, if you can get it.
Tomorrow-
I have no problem.
Maybe it may be in the office of the public prosecutor.
I don't know whether it has gone back
Friday,
or
my
not.
lord, it was there, my
It was on Friday.
Friday, my lord.
Sometimes it goes, sometimes it
Sometimes it may be in our,
may
then I
be.
will.
You can cross check it once. Okay. So what should I do? Fix it tomorrow?
Day after tomorrow. If it is not there, then I will call. We may call it.
All right. Third, Mr. Gogoi, J.C. Gogoi, Learned Counsel and K. Parasat. It was in the submission question. You can take paragraph 2 and 3. Learned Counsel, Mr. Gogoi, Learned Counsel submitting a copy of order dated 13/3/2026, passed by this court in BA 640 of 26. contains that the said order granted bail to a co-accused of this case. Full stop. And drawn my attention to para 6 thereof. Full stop. Uh, The learned additional PP fairly submits that he shall inquire from the office as to whether the case diary is still available. Semicolon, otherwise, comma, he shall procure the same. Full stop. Nevertheless, call for the issue requisition for the case diary of Dispur PS case number 120 of 2026. So and so, so and so. Eta sa power golo dibole. Eta তেওঁৰ some contention of eta likhi dilo. It is also submitted drawing attention to an annex document that the registration number of the vehicle mentioned in the FIR actually pertains to a electric three-wheeler and the learned counsel submits that obviously it cannot be carrying 21 numbers of cattle as alleged. Okay. Place the matter day after tomorrow. Okay.
Highly relevant.
Number 1. Where is the lordship? Wherein behind comma not followed by the and civil lordship, kindly put the order dated 12/2/2026. Page 76 lordship.
Just a minute. He's in custody since 2/6/2026.
Yes, lordship. Which allow by was already allow lordship in the ground of behind command lordship. Similar order lordship page 76. Out of same prodding lordship.
This was rejected,
Notice
right?
lordship 75 yes.
This was rejected, right?
Dictated by this honorable court.
Oh, so this one, subsequent bill application.
Yes, lordship. The ground of behind command lordship.
Oh, John, you're taking that is the subsequent ground.
Yes, lordship.
Okay.
Then lordship page number 75 lordship. Annexal 7 notice lordship under section 50 service lordship.
Co-accused was granted bail
By
or
this honorable court lordship.
huh?
Page 76 lordship.
76. This order is in favor of co-accused.
Yes, lordship. The same prodding lordship on the same DRS lordship. You are the driver, I am the co-driver lordship as per allegation.
Anyway, see. Where is the notice from your
Page
side?
75 lordship.
Just see it from your side first.
Yes, lordship 75 lordship.
Okay. This is the earlier format. Is the scan copy available? It must have been called in connection with the other case. Yes, yes. We can check it from there because scan copies are not returned back, right?
Should be in the court lordship.
Should be in the court, I think.
Everything is mentioned in the earlier order lordship.
First, just
Lordship has to look into it once.
yes. No. As I said, of course I trust you. This one this must be the one. But from the point of view of procedure, as he has rightly said, it is our duty to check it, and they also must be given an opportunity to at least show it. Because sometimes, it is unlikely if it's the same forwarding, but sometimes there may be variation also. Theoretically, it cannot be ruled out. So I think instead of repeating that exercise, we can, I think, get it.
Itself lordship can have.
Or whatever. Scan copy, call police. Do I need to? No. We'll stop. Third, Mr. Amit, learned counsel for the petitioner, and Mr. R.K. Richoru, Deputy SGI, appearing for the NCV. We'll stop. Invoking 483, the petitioner seeking to the previous order, but you can take this part. Page 72,
72.
para 2 and 3. Okay. You know what is the present status of the trial? There were only
702 exam ordinance.
7.
7 out of 13 lost.
Uh,
I have managed the PW also.
This is a subsequent bail application as an earlier bail petition was rejected on 24/11/25 in BA 3115 or 25. Full stop. It is submitted that out of the 13 listed witnesses, 7 witnesses have been examined as part of the trial. Uh, Learned counsel submits that as part of subsequent ground, he has his contention is that notice under 50 CRPC does not fulfill the constitutional mandate in terms of the governing law. Full stop. It is also submitted that co-accused for who was forwarded together with the present petitioner was granted bail on 12/2/2026 in BA 130 of 2026. Copy of the said order has been annexed. Full stop. Mr. Chaudhary, learned Deputy SGI, submits that as the scan case record was called for in connection with the bail of co-accused, he shall try to procure the same. That's okay. Yeah, you'll all registry.
It will be with the registry.
Registry. That it may be available in the court and the registry may perhaps do the needful. As the scan copies are not returned, scan case record is not returned, therefore it is likely to be available and the registry is requested to do the needful to put up the scan record.
Lordship, 48 will be good.
When Thursday, or Friday, Thursday or Friday.
Next Thursday,
This week or
it can be on 20th, Lordship.
Possible 19 may be given, Lordship.
Okay.
Next day, 8th, Lordship. 19 may be given.
I have
Tues-
an outstation matter, Lordship.
you have 20? Yes.
19 may be given, Lordship.
No, he has some difficulty on that. I have no problem. I can give, but you have some outstation work, no? You said,
21st?
no, it's
Or
holiday.
21st, 23rd?
And 20, Lordship.
Right? Okay. No. Junior can
Obliged.
appear also. We have to check that only.
Yes, Lordship. Obliged.
20, this study.
Number 3,
Yes.
may I please your Lordship? Lordship, here in this case, out of the same FRM forwarding, another BA is pending, which is fixed for CD on 19th of March. So kindly maybe take.
Before,
19 March.
should I say appropriate bench also? Before this court,
This for
this password, it was. Anyway, it can be any bench, no issues. Call for the case diary of Bakhisto PS case number 537 of 2025. The accused is in custody since his arrest on 7/1/2026. List the matter on 19.
19.
19/3/2026 along with BA number.
BA number 615/26.
That please, your Lordship. My Lord, this is a anticipated bail, second time bail application, you know. Earlier, this bail was rejected by your Lordship.
It's
And
okay, see it again.
with the observing that some SIM cards and the machines were found during the search, my Lord. But in this case, my Lord,
Aadhaar cards, no?
Yeah.
Documentation, fraudulent documentation, allegations.
allegations, my Lord. But the seizing item that SIM cards and
One
the-
was given, no? One person was given.
one person was given. Other accused are also in bail, my Lord. They have given bail by the learned trial court, Lordship.
Okay.
That order was I annexed. That is that order is annexed at 3/11/21. all the named accused are released in bail. And his name is not shown in the FIR also, my lord.
Where's the FIR? Let us see the FIR once.
Let the up-to-date case diary may be called for along with the report, my lord, the whether the SIM card which are recovered from his shop is activated and the machines, fingerprints machines, they are in order or not, my lord.
Will that be available in the case diary in normal course, or we have to ask for a specific report as he has prayed for,
In the order, Lordship, that
reflected in the order?
send the order.
Okay, no problem.
Specific report may be called for, otherwise, my lord,
Okay.
they will say
It may not be there.
may not be there, my lord. That is
Your good name, please, sir?
NC Das.
And
NC Das.
NC Das, learned counsel for the petitioner. And I learned additional people. Page 18, you will take 2 and 3, para 2 and 3. The it's fairly submitted that an earlier bail petition was rejected on 19/12/2025 in AB 2783 of 2025. Call for the updated case diary of Uluoni PS case number 55 of 2025 on the so and so section. We'll stop. Allowing the prayer of the land council for the petitioner in this regard. The IO may also submit a report indicating what, can you repeat that one?
So whether the SIM card which are recovered for
Oh, yes.
during
Or indicating dash as to whether the seized / recovered SIM cards were activated.
were
Were
activated or not,
Activated, semicolon.
the machines, fingerprints machine, whatever it may be.
And whether the fingerprint machines seized,
Scanner.
recovered,
Scanners,
fingerprint machines, scanners, etc. recovered were activated.
were in order or not?
Were in order.
In order or not?
Whether were in order at the time of seizure. It will like italic statement. List the matter on. Suggested date.
6th of April, 6th of April.
6/4.
March of it.
May I please, your lordships? Lordship, I am here pertaining to the FIR of Badalpur PS 175 2025. Operative portion of the FIR is at page number 11, translated type copy, your lordship. Your lordships, may I please to brief you the FIR.
Yeah, page.
Page 11 is the translated type copy.
Okay, let us read.
Chief, the informant is Reba Deb, and the accused persons are, as per the FIR, 14 and then 10 to 15 more other persons. Maybe around 29 to 30 persons.
What happened?
The facts of the case is that, your lordship, I was at my home, but there is certain ancestral property dispute within my family. And in the house of the complainant, there was a discussion going on regarding the sorting out of the ancestral property dispute. Thereafter, chaos created there. They had a quarrel, and there was an assembly of people from the neighboring house, because all of the neighboring house are also from a blood relative, your lordship.
Can you read it kindly?
I have the honor to state that on 2/10/25, we came back from Vijayadashami and slept at home around 11 p.m. The accused persons came armed with sharp weapons, illegally entered our house and called us. Out of simplicity, when we came out, the accused persons started hurling abuses at us without any rhyme or reason, shoved me, assaulted my husband and son, Samrat Deb, and thus caused grievous injury to them. When I screamed, my neighbors Sanjeev Ghosh, Prabhat Das, Prasanjit Das, and some other persons came to save us from the clutch of the accused persons, whereupon they made a deadly attack on them by means of sharp weapons while asking why they had come there, and thus Sanjeev Ghosh Prabhat Ghosh, Prasenjit Das sustained grievous injury. Having received the information when the police of Marjat Kandi AD camp came to the place of occurrence, the accused persons fled therefrom. Thereafter, with the assistance of the local people, we took my injured husband, son, Sanjeev Ghosh, so and so to Sri Gauri CHC for their medical examination and treatment. As the injury of Sanjeev Ghosh was grievous in nature, the doctor on duty at Sri Gauri CHC referred him to SMCH for better treatment. Thereafter, the condition of Sanjeev Ghosh deteriorated. The doctor on duty at SMCH referred him to Jeevan Jyoti Hospital, Silchar for better treatment, where Sanjeev Ghosh died while undergoing treatment. The second para, that it is mentioned here that when I brought the injured persons to Sri Gauri CHC on 2/10/25, accused Shilpi Dev, that is me, and accused Raj Dev, that is also me, Your Lordship, mother and son, along with other 10-15 tried to come to our house and attack us again. The police of Marjat Kandi AD camp controlled the situation. I therefore pray for this case. Your Lordships, there are subsequent another FIR was filed by the son of the deceased person. But white order dated, it is in annexure number 3, page number 25, order dated 5/1/26. Learned additional CGM Sribhumi was pleased to amalgamate both the cases.
It has to be done. At this stage, let us see the case diary.
Your Lordship, but I have a good case for interim, Your Lordship, because bail was rejected by this court earlier. It has also been annexed, annexure 4.
No issue.
May I please
see it
get some
again.
time to convince Your Lordships? May I please? Because I believe I have a good case for an interim order. Your Lordships.
Please, please.
Your Lordship, all the sections in this case are pertaining to unlawful assembly, rioting, and then common intention to create unlawful assembly, criminal trespass, outraging the modesty, obscene languages, voluntarily causing grievous hurt, using weapons, attempt to murder, and punishment of murder. Now, coming to the point, Your Lordship, the entire set of facts leading to this alleged offense is on the basis of that ancestral property dispute, which is a matter of trial. Thereafter, the informant who filed the first FIR dated FIR number 175 is my sister-in-law, and the informant of the second FIR is the neighbor of my sister-in-law and the son of the deceased. Thereafter, the alleged offense as per both the FIR leads to criminal trespass so and so. But Your Lordship, now me and my son were not present at the PO. We had been called for medical assistance when that person was hit by someone else. It was an assembly there, Your Lordship. And thereafter, when my son reached there, I reached there, we held him to take to the hospital. And thereafter, me and my son on good faith went to discuss with our family members that what actually happened. How so many 30 people can come to a house and create a chaos. Therein, they have very maliciously filed the FIR on 4th, incident on 2. On 3rd, another FIR was filed by these accused persons, but that is still pending. On 4th of 4/10, right? On 4th of October 2025, this FIR number 175 was filed, stating that I have again went there to attack them. Your Lordship, now coming to the direct legal aspirations of this case, is that there is absence of specific overt acts. I have not been found to do something. And then the second one, Your Lordship, is I am absolutely within the territory of the lack of prima facie evidence. I was just a part, and that too I had been called by them. And Your Lordship, all the implications are false and malafide just because there is a case of property dispute. Lastly, Your Lordship, I genuinely am ready to comply with the triple test. I have no flight risk. I'm a very poor person, Your Lordship. I don't have my husband. My son runs a small pawn shop. And today, because of this case, out of this family enmity and personal vendetta, I'm not being able to even earn from that pawn shop. How will I survive, Your Lordship? I have no chances of tampering the evidence because police is doing its work and it is a family matter, Your Lordship. I cannot go to my sister and say, don't do this, don't do that. And lastly, Your Lordship, I have no criminal antecedents.
Anyway, so as you know, since it is a subsequent bail petition, the flexibility is little less in my, to grant. So when can you get the case diary? If we just get the case diary at this stage.
May I submit also?
Yeah, you can submit.
This is
Badarpur,
second-
Karimganj.
This is second bail application.
Yes, yes.
And
You
whether
said also.
there is any new ground, because in first bail
Yeah,
application there is a
subsequent.
if there is
I have
any
to
new
see
ground,
the.
then section 362 of CRPC, and now it is 403 probably, it bars proceed. Because if there is no any ground, then lordship cannot, may not
Yes.
interfere with the earlier order, because this is not a revision or like order lordship.
May I please, your lordship? There is a new ground, that is another subsequent FIR was filed on 18/10/2025, which is FIR number 190.
Which was amalgamated.
It was amalgamated.
But will that be subsidiary anyway? But further investigation, updated investigation can also be new ground. Let us see from the case diary.
That-
Hold on for a few days.
To no lordship, because
Move freely, because I am there to cooperate with the case, your lordship.
Para 8 of your lordships order, last order
I'll
lordship,
see, goes.
that is clearly indicate lordship
anyway,
that
go.
going to the CD lordship that has been rejected.
Okay.
It was rejected because of the
Mr. Sood
objection by
has
the
sued
informant.
Learned counsel for the petitioner and additional people. Sort of page 28 or para 2 and 3 to It is fairly submitted by the learned counsel that an earlier bill petition was rejected on 6/2/26, passed in AB 2664 of 2025. The learned counsel submits that the petitioner number 1 and 2 are mother and son, and they are very poor people, and that they are having a small pawn shop, and due to this case and not having protection of anticipatory bail, she is unable to run her small business as well. Full stop. The learned counsel prays for interim protection at this stage. The learned additional PP, on the other hand, submits that being a subsequent, being a second bail application, new grounds have to be seen. Full stop. Call for the case diary along with medical reports, if any. Updated case diary with medical reports, if any. List the matter.
Yes.
I have no issues. You can
Can have it.
have it. Is it okay? Earlier, you have? Get it earlier. You will be
33 and
then
30.
is 17.
30 lordship.
Can be next. When do you want it? Next week? 30 is okay for you.
30 is okay.
If it's not late for you, it's okay. No problem. 30. 30. Badarpur.
Your lordship, 27, your lordship.
27. You want? Okay. 27.
I like.
Deeply obliged, your lordship.
Item number 11. Earlier rejected the bill, madam. The case diary was called for.
She did not receive, madam.
Hmm?
She did not receive, madam.
And on the legal ground, well,
Borpeta.
but
Is it from?
subsequently,
Is it from Borpeta?
yes, madam.
Fine. Tata sir.
Yes, my lord, all the sections are up to 7 years offense, my lord. But notice is not served, my lord. On that ground, my lord, the interim may be considered at that time, my lord. Sexual concern is, my lord, maximum punishment 7 years.
Second bill application, madam. So short accommodation, madam.
The Anuddin Learned Council and Bosho. Page 19, page 2, para 2 and 3, you take it. Okay. Good stop. It's fairly submitted that an earlier bail petition was rejected on 4/2/26, passed in AB 97 of 2026. Learned Council submits that all the penal sections given pertain to offences punishable up to 7 years, but that no notice under section 35 within bracket 3 BNSS was given. The case diary was as called for is not received today. The learned additional PP seeks some accommodation. Issue reminder for the case diary list on
31st, madam.
give it earlier also. Next week you can give
Then, madam, 27.
26.
26.
I am obliged, my lord. And my name may be shown, my lord, in the cause list.
Yeah, it's not shown.
Not shown.
The name, the name of the learned council and may be shown in the cost list
I am
on
obliged.
next and subsequent dates.
I am obliged. Item number 12.
Sir, please, your
Yes, Mr. Ahmed.
Call for the case diary, my lord, only my lord. Well, see, my lord. Page 12, it is not that a serious offense, my lord. The FIR log, the police person was saying that my receives, my lord, secret information that petitioner who is involved in slaughtering cattle.
Achha.
And according to that is behind the back of the house of the petitioner, according to that spot. Then he covered 45 kg of, my lord, beef.
Diary has come?
Not received.
Not come. There is-
My lord, can you see my lord, my lord. So far as the section 299, 296 not applicable. they're outraging the, my lord, religious feeling of any other community, my lord. As far as section 5 is concerned.
Okay, the only allegations are cattle,
Yes, my lord.
violation of the cattle provisions.
I'm
Cattle.
interim, my lord. It is not that serious offense, my lord. Section, my lord, 5. What is 5, my lord? The prohibition of slaughtering of cattle without certificate issued by the competent authority. 7, prohibition on transportation of cattle.
Yes, yes, I've read it. Familiar with this. Patasar question. Get it within this week.
Not Patasar question, my lord.
Get it on Thursday.
It is Dobuka.
Doboka is Hosai.
Hosai.
Can you get it on Thursday or Friday?
Thursday, my lord, a problem, my lord.
Your problem?
This will be a problem. Because of
20th? 20th? Within this week, we'll dispose it of within this week.
After
Within
it,
this-
then, my lord.
Huh?
25th.
Within his, he has some, he's seeking interest. Suppose I'm not inclined at this stage, actually. Yeah,
My lord,
or on Monday.
Tuesday, because
It's for your wish.
prima facie, my lord, you know, say fine. It
I
is
will
not
see it.
issue of custodial detention.
I will see it on the next day.
But
Problem.
section 13 says,
Hmm.
whoever contravenes,
Hmm.
my lord, the provision contained in the act, under section 4, 5, 6, 7, 8.
Including 8. In our case,
No,
I
no,
think
8 is not there, my lord. 8 is, Kali, 8 is not there. 5, 7, and 13. 8 is not, my lord, inserted.
I think
24th.
anyway, so call for the case diary as called for is not yet received. Issue reminder. The case diary shall be procured positively on the next date. Please the matter on next Monday. What will be the date?
Next Monday is 23rd, my lord.
23rd. Get.
24th.
Oh, he wants it on.
20.
Get it, huh? Get the diary.
Yes.
Huh? 24/1. 24/3. Sorry.
Item 13.
Order it. It's admission.
Please, your lordship. So there is an office note dated 12th March.
Mhm.
As per the office note, this service was duly served upon the sole respondent to OC Nurmati PSC.
Office note dated.
12/3.
Okay. Service report. Insurance also. Feedback after service. Like this. Okay. That's okay.
There was an observation by this honorable court on the previous bills that the matter of entry may be heard after the completion of service.
Is it? What is the matter otherwise?
Matter is
Anyone from the other side? Maintenance matter.
okay,
Maintenance matter.
Lordship,
Without. He's appeared. No.
Lordship, it is a matter.
It will be interim. I think it will be better to have them, no? Isn't it? Huh?
That is an observation of the court,
Yes,
not
yes.
just that steps be taken, because they are lordship deliberately
Yes.
not appearing in the matter.
Oh.
Steps were taken.
Oh, then of course you should not suffer.
And lordship, we kindly see the last order, 4 to 26.
As by directing to pay a monthly maintenance of 12,000 to the respondent and our child. That's the next steps. Sure. Yeah, 12 or 11, right? This is the order. And which order that observation is there? I
Lordship,
think
4 to 2020.
taken up after receipt of the trial court record. Scan copy has been received. I think.
Yes.
Lordship, LCR has come. Lordship.
Have to go.
Please, Lordship.
How about hearing the matter? Because only for interim, no, today.
You see that case
12/3.
is not made.
Today is 17.
May I please, your lordship, the thing is that your lordship kindly peruse the page number 180. Your lordship.
180
180. Your lordship.
of your compilation.
My
Mhm.
No, lordship, page number 179. Your lordship. Your lordship, the dispute between the parties started in the year 2009 when an FIR was lodged. I'm talking this FIR was lodged wide PS number 135 2009 before the old woman PS era 19. Your lordship. Era 19 when an FIR was lodged by the respondent upon the instant petitioner in the old woman PS on 4/12/2019. Your lordship. Thereafter, the matter was registered under section 493, 419, and 34 of the IPC. And in the culmination, the charge sheet was filed by the consent PS. And that matter was forwarded to the Honorable CGM and that was registered with number GR 9456/2009. Your lordship. Then the matter after the full-fledged trial, the Honorable Chief Judicial Magistrate Kamrup Metro Gauhati come to the conclusion that giving the acquittal to the petitioner in this instant petition that the evidence of the petitioner is highly contradictory and doubtful one and fully unreliable. And your lordship, in the page number.
He was acquitted.
He was acquitted, your lordship. Regarding the,
And this, the order against
Then-
which you have come,
Yes.
that is the order of,
that is the order of Principal
Family-
Judge, Family Court number
Fa-
1,
okay,
white dated
FC of Gauhati,
20
family court.
Guwahati Metro, your lordship, dated 28 August 2025.
Can you help me
It
with
is
the
on
page number?
It is on page number. Lordship, from starting from 228.
Another thing has come to my mind that will it be proper to wait another week to see if somebody appears, or if they don't appear, then I mean we should not wait. Then we should take a call on the interim prayer this way or that way.
So the urgency is that the execution proceeding has been registered
Hmm.
and tomorrow the date.
I understand. 12,000. Are you willing to pay something for the child? No.
The marriage is disputed as well as the child.
Huh?
The marriage is disputed.
Okay.
Our contention is that.
Paternity is also disputed. Paternity marriage.
By no stretch of
So he doesn't want to pay anything.
The sole contention is that the marriage is not even established.
No, there is
The acquittal of this case makes evidence contradictory to those things. But
Mm.
totally, she's running contradictory.
See it. We can hear it also, but again, there are older matters in the queue, you know, otherwise matter can be heard also actually. But anyway, this,
Till that date, but if the date is falling for execution, but till that on 30th, your lordship may fix the matter and test out also. Lordship. By then, if they appear, lordship can make an.
some protection till next date.
heard Mr. So, learned counsel for the petitioner. Who has filed this revision. It's a revision or criminal petition?
Reason.
Revision. Agreed by order dated
28.
Passed by the learned, order dated 28/8/25. Passed by the learned Principal Judge, Family Court, number 1, Kamrup Metro, Kamrup M. Gauhati in FC Criminal 327 of 2014, whereby the Family Court was pleased to direct the petitioner/second party to pay a monthly maintenance of 7,000 to the petitioner and rupees 5,000 to the minor daughter from the date of filing of the case. It is drawing attention to the office note dated 12/3/2026. It is submitted that the said note indicates completion of service upon respond number 2/first party. Sole respondent? Sole respondent. I peruse the said office note. Service is complete upon respond number 2. Today, none appeared. Full stop. The learned counsel has also drawn my attention to the order dated observation in the order dated 2/12/2025 that the prayer for interim stay shall be taken up after receipt of the trial court records. Full stop. The scanned TCR has been received. Full stop. The learned counsel submits that execution process is also started, and that one of his main contentions is denial of the marriage itself. Can I record that? Including paternity of the child. Full stop. So that we can do, fix it on 30. Until then, we can, give you some relief.
There will be considered.
In the section circumstances, the execution of the order dated so and so,
Execution number is 7725.
the impugn order dated so and so shall remain stayed. That will do, I think, till the next date of listing, right? So list the matter on 30th, 30. Let's see. Otherwise, we can go into merits and try to do something else. 30, okay? 30th.
14. May it please, your lordship. There is a delay of 511 days, your lordship. May I pray that delay may be condoned?
What about notice? No private respondent,
No private respondent, right?
Let respond.
No, there is a private respondent, Your Lordship, but there is an order of this honorable
Is it
court, Your
Fox-
Lordship.
is-
He is a police officer. There is an order, Your Lordship, may kindly produce at 17/12/2025. Public prosecutor has accepted notice on both the.
On behalf, yeah, the public official, you can represent. So
There is a delay, Your Lordship.
you are aggrieved by framing of charge, right?
Yes, there is an amalgamation of an order, Your Lordship. I am aggrieved by that particular amalgamation, Your Lordship.
Amalgamation of
Amalgamation of two cases, Your Lordship.
two
That's-
cases.
Yes, Your Lordship.
Okay,
Maybe-
you are challenging the amalgamation or framing of charge?
The framing of charge as well as the amalgamation, both the things. The same order, Your Lordship. The charges, the cases are amalgamated and charges are framed. In one case, Your Lordship, I am the informant. In the
Mhm.
other case, I am an accused. Both
Mm.
the cases, Your Lordship, are not from the same transaction.
Mhm.
Still, Your Lordship, the cases were amalgamated and the charges were framed.
Okay, is it? Any stay order? Is
No,
there?
Your Lordship. I'm praying that this proceeding may be stayed, Your Lordship. Was, Your Lordship. The
No,
delay- delay, Your Lordship.
but now we are on the delay condonation.
Yes,
The
Your Lordship.
Impugned order is 3-2,
Yes, Your Lordship.
3-2.
3/2024.
During the hearing, it's felt that.
The order starts at page 61, 68, Your Lordship.
Hmm?
68 of my petition. That's the order.
Okay.
I've
No, you have a order here also, 11, page
Oh, yes,
11.
Your Lordship.
This is the same order, right?
Same order.
Let us read.
Page 11.
I'll just flip through it. Huh? Then I'll see the ground, since the delay is slightly on the higher side,
Yes,
we'll
yes.
see the ground. Okay.
Think that the delay may condone, Your Lordship.
The charges are framed under the same section.
Yes, yes.
Same section. Same transaction, as you know, as you rightly
Yes,
say,
sir.
pointed out. That is the test, right?
Yes,
Same
sir.
transaction. Suppose you hit me, I hit you, suppose.
Yes,
We'll
sir.
never hit each other. Of course.
Yes.
But so, so that will be same transaction.
Yes, sir.
Something like that. That's an easy example. But here, one person came to exchange currency allegations, and they also, something else also happened.
They were robbed, Your Lordship. The
Robbed.
persons who came, they
Mhm.
were robbed. And the other persons said, they are the persons who have
Yeah,
conspired.
this thing. Let us see the grounds.
If Your Lordship allows me, may I
Yes.
submit a judgment, Your Lordship?
Yeah.
Honorable Supreme Court, Your Lordship.
Will help.
AR 2026, Supreme Court of. Five zero seven. State of Delhi versus Khimji Bhai Jadeja, Your Lordship. Paragraph 19 and 20.
The recent decision,
Yes, Your Lordship.
this will take up if it is the delays condoned and we go into the merits.
yes, yes,
At that time we can,
We are the only party, Lordship, state is the party.
yes, yes. I'll come to
Didn't we
you.
condone, Lordship? Website, no.
Huh?
Didn't we condone, Lordship?
But since it is high delay, so the grounds have to be,
That is
discussed.
very yes.
That's what I'm saying. There was a previous proceeding. Let us see page 4,
yes.
page 4. So, this is the
If Your Lordship may kindly take up the main petition for a moment, I can.
no, para 4 of your delay condonation at
Yes,
page
yes.
5. The filing the criminal revision, you're talking about this criminal revision only.
Yes, Your Lordship.
No previous petition
No,
was
no, no.
filed.
This.
No problem. Let it be delayed. We'll be going to the merits and see it later. Or TR Dairy. Your good name, please. You can give your name. No? Could you take the name?
You Bharadwaj, Your Lordship.
You
Ujjwal
Bharadwaj, learned counsels for the applicants. Also heard learned additional PP for the for both the respondents. This interlocutory proceeding is arisen out of an application under Section 5 of the Limitation Act 1963, seeking condonation of a delay of 511 days in filing a criminal revision against order dated 3/2/24, as by the learned special judge Morigaon. By the said impugned order, the learned special judge was pleased to amalgamate Jagiroad PS case number 451 of 21 and Jagiroad PS case number 453 of 21, being special sessions case number 13 of 22 and special sessions case number 14 of 22 respectively. Full stop. Pursuant to such amalgamation, the learned trial court was pleased to frame common charges under section 120B, 489A, 489C, 489D IPC. Stop. The grounds for the delay have been narrated in para 4 of the application. It is stated that the delay occurred due to lack of persons in the family of the petitioners who could come to Gauhati and meet the council and to prepare the case. It is also submitted that the revision had to be prepared to challenge the amalgamation as well as the framing of charges. They are residents of West Jaintia district.
Yes, Your Lordship.
They submitted that the petitioners are residents of, the petitioner, right? Single petitioner.
Both, two of them are here.
The
One
petitioners
word
are resident of West Jaintia Hills district
Yes, sir.
in the state of Meghalaya. Full stop. The prosecution fairly submits that there's no objection to the delay condonation. In the facts and circumstances, as the petitioner is considering in the facts and circumstances, considering the grounds of delay condemnation adduced, and also that the petitioner is aggrieved by framing of charges against him, give a dash. I deem it in the interest of justice to condone the delay. Accordingly, the delay of so and so days, 511 days, in preferring a criminal revision is hereby condoned. The IA stands disposed of. The revision may be registered and put up for admission. Okay.
I'm very grateful.
I'm keeping this here, huh,
Yes,
so that we'll study.
very grateful. Your Lordship.
Vijay.
Visual item 6.
Yes.
Please, your Lordship, this application has been filed against the order dated 10/8/2023, which was passed by the learned Judicial Magistrate First Class Lakhimpur in an application filed under section 239 of the CRPC for discharge of the petitioners from the allegations. And Lordship, when considered the application filed by the petitioner, the learned court below, your Lordship will find a paragraph.
So the prayer for discharge was rejected.
Yes, your
That is
Lordship.
the crux of the matter, right?
And if your Lordship will come to the first FIR, your Lordship will find that the FIR, Lordship, on the face of the FIR, it reveals that the intention of the petitioner in comparison to the charges submitted by the police after the investigation, it's only, Lordship, just to with an ulterior motive, just to wreaking the vengeance of the Lordship petitioner, Lordship, petitioners. Your Lordship will find at page number 15, Lordship. And in this case, Lordship, there is also some private respondent in the matter, Lordship.
Here, she has been served, no?
Lordship.
She has been served. Private. The respondent number 2 has been served. Service
The service has been completed, Lordship.
completed.
Yes.
No problem. Okay. Should we try disposal? Yeah.
The
CD will be necessary. CD has come.
trial court TCO has come, Lordship. Already representation of the private respondent is necessary because
Yeah, it is necessary. Otherwise, but law does not compel you to appear in any case. So if only thing service is complete, has to be
service has
complete.
been
Of
complete.
course, in POCSO and all, because of the nature of the case, we appoint an amicus. But in this case, it's not necessary.
Fine.
What is the nature of the matter?
Your Lordship may kindly come to page number 15. Page number 15 is the translated portion of the FIR, Lordship.
Let me just see the, when was when notice was served? I'll come to that, what you're
Yes,
saying. Office note or whatever.
Ask the portion that can be given.
List on. A. Hassan, I.K. Borgohain, they've appeared also.
Yes, Your Lordship, that's why.
2511 they've appeared.
Maybe due to some difficulty. No.
Wakalatnama has been filed, but are they appearing? Yeah, I think they are not appearing. They're not appearing, it seems. Okay, now we'll see this, huh? Page 15.
Page 15 is the translated portion of the FIR. May I read the Lordship
Yes.
FIR?
Let us read it.
In Lordship, informant is Noornahara Begum, wife of Muhammad Abdul Manaf, residents of so and accused are Raghu Gogoi. The first accused is, Your Lordship, may kindly find the Raghu Gogoi.
Mhm.
And the second accused is Niru Soikia Gogoi, and third is Dipen Fukon, and fourth is
Kula
Kula
Gogoi.
Gogoi. Sir, with due respect, states that on 1/5/2010, Sri Raghu Gogoi took an amount of rupees 12,000 each to tell 36,000 from me and resident of Mornoi Sapori village, Miss Zahira Begum, wife of Abdul Kalam, and resident of Mornoi Sapori, Miss Asmina Begum, wife of Ziabur Rahman, at his residence with the assurance to give the job of worker and helper at Umalaghar, and thereafter on 24/5/2010 and 3/5/2010 given under given order copy, one copy to each, signed by the accused number 2, 3, 4, 2, 3, and 4, and accordingly after discharging duties when we did not receive salary, then on inquiry came to know that the order copy signed by the accused number 2, 3, and 4 was a fake order. Therefore, we have requested the accused number 1 to return the money, but he always giving false assurance. Therefore, it has been delayed to lodge the FIR. Sir, in this way, the accused had misappropriated our money. FIR has been written according to my brief, and same has been read out before me, and as such, I have put my signature. Now, Your Lordship may kindly come to the search sheet submitted by the police, Lordship. Thereafter, Lordship,
Mhm.
Your Lordship will find at page number 18. Relevant parties, Lordship, page number 19.
Translating.
The type copy, Lordship. It is mentioned here that the name accused in the FIR Sri Raghu Gogoi has been discharged from the case, as no sufficient material and evidence has been found against him. Warrant has been issued against the absconder Sri Dilen Pukon. Therefore, it is humbly placed before Your Honor to prove the case through the below mentioned witnesses. Means the Lordship, the prime accused who has been Lordship accuses in the FIR, he has been discharged by the police. Lordship, in the
Let
event
me
of
just,
that, no prima facie evidence
yeah.
against the
Uh,
Raghu Gogoi has been found during investigation.
visited the place of occurrence, so and so, so and so, so and so. Against Bandana. Has been submitted against Kula Gogoi, Niro Saikya, Bandana Gogoi. Mentioned that name accused in the charge on the case. No sub. Okay.
And the when Your Lordship will compare the FIR, Your Lordship will find that the allegation was against the Raghu Gogoi.
Yeah, FIR all
FIR
it
was
was there.
only Raghu Gogoi.
It was there.
If Your Lordship will kindly come to page number 54, then Your Lordship will find the statement of Lordship victim that name in the FIR, Lordship.
Can we see the can I see the impugn order once?
Yes, Your
This is the
Lordship.
impugn order.
Impugn order, Lordship, Your Lordship will find from page number 23.
It's a long order.
Long order, Lordship. Because Lordship, the entire case has been made out by the police implicating the Lordship, the petitioners in the present case. Lordship, only on the basis of the individual Lordship and independent statement of the Lordship witnesses. There is no corroboration, Lordship, in the statement of each other, Lordship.
Mhm.
Page number 23 starts from page number 20.
Yes.
May I read, Lordship?
Yes.
The
can-
accused person, namely Miss Bandana Gogoi, Kula Gogoi, and
Let us read
Mrs.
this.
Niru Soikia Gogoi and Dylan Fokon are present. Today, the instant case is listed for passing of order on the petition and white number so and so, file under section 239 CRPC by the accused person paying for discharge them from the offences under section 420, 468, read with section 4 of the IPC, as well as against them in the FIR registered by Vipuria PS case number 261/2012. By petition number so and so, the accused person reproduced the FIR which was filed on 4/11/2012 against the accused Raghu Gogoi and the present accused person except Bandana Gogoi. Pursuant to the said FIR, charge sheet under section 420, 468 and 34 IPC of the Indian Penal Code was submitted against the present accused person, but the accused Raghu Gogoi was not sent up for trial. The accused petitioner contended that it is clearly stated in the FIR that the informant had given the money to one Sri Raghu Gogoi, and there is no corroboration between the statement recorded by the investigating officer herein after IO and the averment made in the FIR. As such, there is no prudent evidence to prove the fact that the accused petitioner had committed any offence as alleged in the FIR. It is further contended that the FIR was lodged after almost 2.5 years from the date of occurrence, and as such, delay in lodging the FIR often results in embellishment, which is a creature of an afterthought, and it was lodged implicating the petitioner accused person, but the informant had not even stated a single word against the present accused person before the IO about their involvement in the aforesaid alleged offence. According to the accused petitioner, no prima facie case is made out, no such prima facie evidence was found, and no grave suspicion appears against them, implying their involvement in any of the offences alleged in the FIR. Hence, they prayed to discharge them from the offences under section 420, 468 and 34 IPC alleged against them. I had already heard both the sides. The Learned Defense Council submitted that the FIR was lost after a gap of 2.5 years, which implies that it is an afterthought resulting into embellishment of the fact of the case, and he put his reliance on the state of Andhra Pradesh versus M. Madhusudan Rao, so and so, wherein it was held that by the Apex Court of India that no explanation what the name for delay in filing the complaint with the police has come on record. We are of the opinion that this circumstance raises considerable doubt regarding the genuineness of the complaint and veracity of the evidence of the complaint. PW1 and her father PW3, rendering it unsafe to base the conviction of the respondent upon it. Resultantly, when the substratum of the evidence given by the complainant PW1 is found to be unreliable, the prosecution case has to be rejected in its entirety. There is an observation of the Honorable Supreme Court in this regard when the cause of delay, Lordship. He further argued that the prosecution could not make a prima facie case against the accused person, and in this regard, the Learned Defense Council relied on Dilwar Balu Purane versus State of Maharashtra, wherein it was held that in exercising power under section 227 of the Code of Criminal Procedure, the settled position of law is that the judge, while considering the question of framing the charges under the said section, has the undoubted power to sift and weigh the evidence for the limited purpose of finding out whether or not a prima facie case against the accused has been made out. Where the material placed before the court disclosed grave suspicion against the accused, which has not been properly explained, the court will fully justify in framing a charge and proceeding with the trial. By and large, if two views are equally possible and the judge is satisfied that the evidence produced before him while giving rise to some suspicion but not grave suspicion against the accused, he will be fully justified to discharge the accused, and in exercising jurisdiction under section 227 of the Code of Criminal Procedure, the judge cannot act merely as a post office or a mouthpiece of the prosecution, but has to consider the both probabilities of the case, the total effect of the evidence and the document produced before the court, but should not make a revoking inquiry into the pros and cons of the matter and weigh the evidence as if he was conducting a trial. There is, Lordship, it is also relevant to the FIR as well as in the Lordship charge sheet submitted by the police. The learned defense counsel further argued that nothing was recovered from the possession of the accused person, and also prosecution could not produce any money received or evidence that the informant and the other victim had given money as alleged in the affair. There is also no grave suspicion against the accused persons that they had committed the alleged offense. In this regard, he put his reliance upon the state tier inspector of police versus Arun Kumar and another, when it was held that it is clear that at the initial stage, if there is a strong suspicion.
For the moment, we can skip this part. Huh?
Yes,
We
Your
can
Lordship.
skip this part.
They-
You come to this page 28, second para,
Yes.
right?
The learned defense counsel.
Yes.
The learned defense counsel took the plea of contradiction of the above named informant and witnesses with the averment made in the FIR, and according to him, no prima facie case is made out, and the accused petitioner are meant to be discharged. The learned assistant public prosecutor herein after FPP, the prosecution objected the petition number so and so. She relied on the documents is in this case. The appointment certificate is by so and so, which was issued by the office of the Subansiri Welfare Society, Dhokwakhana, bearing registration number so and so, to the informant victim were duly signed by the accused so and so, so and so, so and so, and respective date of joining was also mentioned therein. The list of persons who joined the said society along with membership fees. Lordship, there is also one important document. According to the learned PP, in the instant case, the informant and the other victims were induced to give money to the accused person on the pretext of giving jobs, and then they were not given any job even after being furnished with appointment certificate, which caused harm to that person in mind, resulting into the offense of cheating as per definition of cheating as provided under section 415 of IPC. She had further contended that the appointment certificate are false, and hence they were not given any job even after being given appointment certificate. The learned PP so-and-so also stated that the witness and the informant both in their statement recorded under section 164 and 161 CRPC had implicated the accused person, and the learned PP further brought into the notice of the court that though the accused Bandana Gogoi is not in the name FIR, but she is the wife of FIR name accused Raghu Gogoi, and she has been implicated by the witnesses in their statement recorded during investigation. She has humbly submitted that the accusation and the evidence adduced in the case are sufficient to frame charge against the accused person, as there is a need for trial in this case. I have thoroughly perused the case record, the petition number so-and-so case, the statement of informant and the witnesses recorded under so-and-so, and his appointment and certificate and other documents. On perusal of statement recorded under section 161 and 164 CRPC, it appears that informant Nurnahara Begum mentioned in the name Asmina Begum and Zahira Begum in the FIR itself. On a plain reading of their statement, it gets revealed that the informant and the Asmina Begum and Zahira Begum had given 12,000 to one Raghu Gogoi on so-and-so respectively. Abdul Manaf, husband of the informant, also stated the same in this regard in his statement. The statement was against the Raghu Gogoi, Your Lordship. So far as the plea of contradiction taken by the learned defense counsel is concerned, the learned defense counsel has selectively only considered the statement of the informant and other victims named in the FIR, wherein they did not take the names of present accused petitioner. However, I have carefully read the statement of witnesses recorded under section 161 and 164 CRPC. It is entirely, and so far as the case diary is concerned, the witnesses, namely Riju Das, Manoj Lohan, so-and-so, Titheswar Das and Rupamani Das implicated accused Kulogogoi. The witnesses, namely Meena Khandal, Kobita Bhujel, so-and-so, Titumoni Fukon, Swala Hazarika and Radhika Hazarika implicated the accused Bandana Gogoi, and the witness, namely Zahira Begum, Nurnehara Begum, Abdul Hanaf, Asmina implicated FIR and named accused Sri Raghu Gogoi. And all the witnesses stood firm in their statement recorded under 164 CRPC regarding the amount of money they had given to the accused Kulo Gogoi or accused Bandana Gogoi or to the not sent up FIR name accused Raghu Gogoi. However, The only discrepancy was found was regarding the debt in my opinion, it is immaterial to consider this plea of defense counsel at this stage, as these minor contradiction or discrepancies are found in the FIR and statement recorded under section 161, which are not substantive piece of evidence. Also, in so and so, this part I. Moreover, the appreciation of evidence regarding contradiction and corroboration is usually done at the trial stage, and at this juncture, I am reminded of the judgment passed in so and so. Coming on the plea of defense that there is no prima facie case as an evidence, I have perused this is document and which when and juxtaposed with statement recorded both section 161 and 164 CRPC disclosed that allegation that money was taken from victim on the pretext of giving job at Molaghar was not groundless. At the prosecution side submitted the appointment certificate duly signed by the accused person, Niru Gogoi, Dilan Soika, along with the list of people wherein in one column named Swadesh Somasol is recorded against each of the persons listed therein, including the informant and other witnesses. The defense side also did not deny the signature of the accused person and the fact of issuance of the appointment certificate, resulting giving rise to a prima facie case as to whether victim were being seated by using forced appointment certificate. Lordship, this here in Lordship, it is completely reflected that it is not a Lordship appointment letter. It is a Lordship Sodesya Masal. The piece
It is
it's a Sodesya Masal. Lordship, your Lordship will find membership fees, Lordship. It is pertinent to mention that it was held in so and so at this stage framing of such so and so. Lordship, further in last part, Lordship, also it is to be mentioned that in a latest judgment passed by the Honorable Supreme Court in so and so regarding, Lordship, now come to the Lordship regarding the delay, last paragraph, Lordship, of 34 pages. These are the judgment I have, Lordship.
Last paragraph. Last paragraph
34. Regarding the delay caused in lodging of the FIR, lodging of the alleged FIR, it is to be mentioned that the case was lodged within the limited period, and the informant explained in the FIR itself that accused Raghu Gogoi had given them excuses day after day, which resulted in the delay in lodging the FIR. Lordship, the person who is the prime accused in the FIR, he has been further, after recording the statement of witnesses, he has been discharged from the all charges. And question of Lordship, ground of delay, Lordship, showing the causes, the Lordship that Raghu Gogoi is the main Lordship culprit who made the delay. It cannot be, Lordship, a ground, Lordship, the prima facie case, Lordship. Resulting now at this stage where there appears a prima facie case against the accused person, this explanation of the reason for delay in lodging of the FIR seems plausible for the purpose of proceeding with the case and to conduct trial. Let me reproduce section so and so. Now, therefore, again, Lordship, your Lordship may kindly come to last paragraph of the page number 35. Therefore, in view of the above and perusal of all the materials on record before this court is of the humble opinion that all the witnesses stated in conformity and all they also implicated the accused person, and the defense did not challenge the appointment certificate. Now, Lordship, the Honorable Court has observed that, Lordship, I have not challenged the appointment certificate, Lordship. Did not challenge the appointment certificate, implying that the accused petitioner issued the same which is give rise to grave suspicion against the accused person, and a prima facie case is made out against them, and the accusation does not seem to be groundless, which is very well justifies to conduct trial to unearth the truth behind the alleged fact in this case. It is pertinent to mention here that the learned defense counsel submitted that the ingredient of section 420 IPC are not fulfilled as per the alleged fact, and section 420 IPC is not attracted. Also, as stated, he stated that there are no element of sitting. Therefore, section 468 IPC is not attracted in this case. This plea of defense that the offense under section 420, 468, 34 IPC alleged in the charge sheet are not attracted will be very much considered at the time of consideration of search. Lordship, this is the this application has been filed against the framing of search. Now the court will decide at the time of framing of such lordship. There is a contradiction of lordship, opinion of the honorable court lordship. According, taking into consideration of all the materials on record, the submission of the learned counsel and the statement recorded in due course of investigation, and in view of the above discussion, I deem it fit not to discharge the accused person at this stage. Now again, honorable court has said that lordship, if the court is not inclined to discharge lordship, and the entire case has been considered at the stage of while considering the application made under section 239 and of CRPC law for lordship discharge the petitioner's lordship. And now your lordship may kindly come to the statement, statement which has been relied by the honorable court while rejecting rejected the lordship application filed under section 239. Your lordship may kindly come to the statements.
I think, Mr. Bosso, I think I thought that we should stop here. We'll keep it part heard. And then because it will be better if they are present, the other
As because
private respondent, when the statements are discussed, because these are the main things.
Yes,
But I have understood. So only thing that the learned court has said that, 3 sets of witnesses he has mentioned, and they have implicated so and so, including the petitioners. And this is also there in their 164 statement. So we have to cross check for that. Just check it once whether, because if anything is deficient, we'll have to call for it again. You cross check it once whether it is there. Otherwise, we'll stop here and fix a date, short time, within a short time.
After Bihu vacation lordship, because
Okay,
I have some civil.
Okay, so it is better we keep it, short after view, because otherwise it should be, there in the memory. Then otherwise, if it's very long, so we may forget. I may forget. Heard Mr. Sharman,
The Sharma, yes.
learned counsel, assisted by
So,
learned counsel for the petitioner. Full stop. Learned K. Boyso, learned additional PP appears for the state. Upon perusing the case record, I find that as per office note dated 25/11/2024, two learned counsels, 3 learned counsels had entered appearance on behalf of the respondent number 2 by filing wakalat number, full stop. However, none appears for the said party today, full stop. The scanned record as called for is available, full stop. The learned counsel addresses arguments in part. The matter may be kept as part heard. List the matter. You can choose a date as per your convenience.
after vacation,
You can choose a date as per your diary. You can choose a date
25th April.
after Bihu
Yes, your lordship.
vacation. Two weeks.
20,
We don't know.
Let it be on 23rd.
hearing day.
23rd April.
Yes, your lordship.
Okay, 23/4. In case I go outstation, get it adjusted after
Yes,
that,
sir.
after I come back. Outline. It is list on 23/4. Okay.
Highly obliged.
Number 8,
Item number 8, my lord, I think. Respondent number 2 is also not present, my lord. And we also need to, my lord, go through the, my lord, PCR, my lord. POXO matter, my lord.
POXO, it is for quashing.
Question, my lord.
Quashing.
Against the cognizance.
Against the cognizance,
Sir.
taking of cognizance. You are for the informant.
Pray for a short accommodation, my lord, because, my lord, we are not able to go through the, my lord, TCR, my lord, today, no TCR receipt, my lord.
Interim orders there. Okay, then you work out a date, mutually convenient date.
Election officer. After whom, my lord?
The learned additional PP also seeks a short accommodation. The TCR,
Today. You said.
in the previous matter, no, just have a look, whether anything is complete. In this, it is come, no? This has come.
Here TCR come.
Scan TCR is already available, full stop. Full stop. What did I say? Short accommodation. No, sit down, please. Sit down. Please. Sit down. Short accommodation. Full stop. Today, the TCR is available. The scan TCR is available. Full stop.
25 or 24.
The interim orders passed earlier shall continue till the next date of listing. List on
23rd, my lord.
23rd of April. 23/4.